many downstream questions as a result of that that are left unanswered by courts right now, that acting as though we can just sit and say, all right, well, the courts have decided that some things are securities, we're done here, let's head back here in 20 years, is clearly insufficient. So that's one challenge. And when I'm talking to my founders, whether it's in the DeFi context, whether it's in capital formation, whether it's something else, all of those things are in mind. And I would say that generally speaking, while I've got some maybe gaps or maybe distinctions from where I'd say Miles' kind of theories land, I'm generally aligned with, I think, the notion of control being a central feature of our assessment. Now, I think, again, that's relevant for both an exemptive framework, but also taxonomy questions. And I think that's also something that we need to maybe delineate some as we get through this conversation, because some of us are talking about purely classifying assets as securities or non-securities. That's at the top of the funnel, although arguably the very top of the funnel is, do we have a securities transaction or do we have an exempt security? But once we get past that, then the next question is, do we have a security or a non-security? Those are top of the funnel, I guess, questions. But after that point, I don't think we've got, what's the right word here? I guess I don't think we have the right substance to get to the sub points of our assets. So for instance, in I believe Miles's comment that they submitted, they've got a proposal where you look at, once you're in the securities world, what type of asset might this thing be? Is it an asset-backed token? Is it a token with intrinsic securities, properties? Is it some other type of thing? Those things will probably all have relevance for the type of exemptive relief that may apply. It doesn't necessarily mean that all those things aren't securities, but it might mean that we may not need to have certain types of disclosures for certain assets that inherently provide information in the operation of their system relative to something like
Thanks very much. And let me thank the SEC and the Crypto Task Force for this event and for having me. I want to echo what John said about Commissioner Purse. It's been a privilege to work with her in the past and for having me. I want to echo what John said about having worked with the SEC and been a privilege to work with her in the past. As to the question for having me, I want to echo what John said. I think the policy is so fundamental to this question. As to the question because I think what has to underlie every policy decision that the SEC makes is the SEC's mission. And I totally believe in the three-part mission that the SEC makes. Information is important, mission. Markets are important, but I also believe in the three-part mission is very, very important. And so when you're thinking about the question of what is a security, I think you have to think about, well, how can you best, when you're big investors, what is security? I think about it from the perspective of investors. And I agree with what John said, that from my perspective, investors are purchasing crypto assets as an investment. And I think that, that should inform the question. I think if investors are being marketed these assets as an investment, being told, hey, if you buy this, if you give us your money, we'll do things with the money, and then you can profit from it, that seems like a security. And I think that has to inform the discussion. I went yesterday to look at the websites of some large broker-dealers, and on the webpage of a lot of them, not all of them, but a lot of them, there's always a tab about products that they offer. And in a lot of cases, they say stocks, bonds, mutual funds, ETFs, crypto. I struggle with the idea that only 4 out of 5 are securities and not all 5. But even if you disagree, I worry that investors would be confused, right? Can it really be the case that they're going to understand, even if you envision a world where all crypto assets are deemed to not be securities? Are they going to understand that, or are they going to not understand that and be put at risk as a result? And so I think that that question of how can you best protect investors and how are these products being marketed to investors is really fundamental.
Can I just jump in only because I've heard the Chris view just mentioned a couple of times, one of the occupational hazards of going first. I did want to just for clarity, when I was starting, and maybe this is helpful for the conversation or maybe it's not. Ultimately, the question was framed for, well, what do you sort of think about the optimal sort of elements of a crypto regime? And to reiterate what we've already heard, there are different objectives. There's investor protection, and capital formation is also very important. And by the way, capital formation itself creates all kinds of interesting questions as to the regulatory perimeter. But once you do fall in that perimeter, the commission does have plenty of rulemaking authority. It happens all the time. I mean, courts make decisions, commissions then go about and they craft rules in response. They have exemptive authority, even with regards to primary legislation. The risk element was, you have to have a starting point for saying, okay, well, why are we involved in the first place? And then you have to take the secondary step of identifying, well, what's the appropriate regulatory response? If there isn't any, and this is, I guess, to echoing different folks at different times, but caveat emptor is not a regulatory strategy, and that's what we've had, and then you end up, complicating efforts to both protect investors and also to promote capital formation, and that's a challenge. I said my piece. All right, thanks.
Great, thanks, Chris. Rodrigo. So you've been at a fund, now you're practicing. From your perspective, having had the chance to hear what's been said, as well as just your experience, is there one thing in particular that you think the commission could or should do, or at least could or should consider doing?
Thank you. I'm Rigo Seda, special counsel at Cooley. So maybe I'll try to respond to some of the earlier comments and get to the conclusion of what I think they could do. I think it's key first to understand that just because there's investment intent behind the purchase doesn't turn that transaction automatically into a security, right? I think that's a logical fallacy and something that would basically mean that securities law would eat the world and not one where I want to live in, right? So I think we have to be careful about the way that we shape this regime, understanding that we need to protect the capital markets and make sure that we don't create any loopholes, but also make sure that we're developing a framework that doesn't end up, again, consuming the world. I, for example, was talking yesterday over dinner about how I like to purchase art. Last week I was in New York. I purchased a piece from a young artist, partly because I liked it, I thought it was cool, but also it was somewhat of a bet that he would keep working, and he had a couple of shows lined up that I thought were interesting. I don't think that means that that transaction all of a sudden should be regulated as a securities transaction, right? I think I want to push back a little bit on this idea that the case law has been clear when applied to crypto, right? I think it's important to distinguish between the couple of waves of enforcement that the SEC brought. The first wave was really centered around ICOs and fraud. And it was mostly against defendants that didn't have the money or the incentive to fight a SEC enforcement. So a lot of those ended up in settlements, right? And I think from some of those, we can take the premise that when you're selling crypto assets in a fundraising transaction, that fundraising transaction should be regulated by securities. And I think most of us on this panel would agree on that, right? I think the second wave of enforcement that focused more on intermediaries and brought pure registration violations. And it also targeted as defendants companies that had the resources and incentive to fight about the company litigation, resulted in a much more mixed bag of results, right? I don't think the SEC itself was clear in those cases about what it actually considered to be a security. The judge in the Binance opinion kind of chastised the staff about this, where they had flip-flopped between what exactly was the investment contract. And then I think we can't look over the fact that there was a split even in the same district court over how we extended to secondary transactions. When you look at Ripple and you look
And
at
if we
the
could
Terra
just,
opinion.
if we could just not talk about any specific cases, that'd be great.
Sorry, apologies for that. Anyways, I don't think it's true to say that the law is clear. And from the practitioner's perspective, I can tell you that I don't know what the law is. You have to somewhat try to advise people from general principles here, right? I think it's also important to understand that the current regulatory framework, the securities regulatory framework that is premised on registration and disclosure, is not fit for purpose for all crypto instruments. What might apply for fundraising transactions, I think if we just fit crypto, if we jam it into securities, we're going to end up deprecating a lot of its unique qualities, right? Crypto, at least for me, the reason I got into this space was because I saw it as a technology that enabled a new form of human collaboration, right? It allows people to come together in a digitally native way and collaborate over open source and public goods in a way that wasn't possible before. And it gives people technological rights within a system that I think are, or I guess I should say technological powers within a system that I think are different from legal rights. So I don't think that just forcing the registration and disclosure regime onto these systems is going to really address the policy goals. And if you follow the downstream effects of doing that, I think it actually really handicaps the development of crypto in the United States. Yeah, and I guess finally, to kind of respond to the idea that the SEC has predetermined that certain actions or certain tokens are not securities, or they've there's some whiplash here. I think to me that is an attempt to regulate with humility and a sense of responsibility that is very important, and it comes from the premise of we're all here with varying points of disagreement. It's required of a regulator when they're doing their job to, I think, first clarify these points of disagreements before you take somebody to court and try to figure it out there, right? So I actually commend the SEC on their new approach of like engaging with industry. And I think, frankly, needs to be a lot of work done to rebuild those channels of communication and trust between industry and regulators that I think are ultimately going to leave everybody off in a better place.
Great. Thank you, Rodrigo. So Lewis, so you've written a lot on Howey as applied to crypto. And as I understand it, one of the distinctions you've drawn often in your writing is an investment contract, if it exists, from the token or a token or a crypto asset. Can you explain more conceptually that distinction? And beyond conceptually that distinction, practically, how does one identify when that distinction actually exists?
Sure. Thank you, Troy. And thank you, Commissioner Peirce, and to the whole SEC staff I just second Rodrigo's thoughts of the importance of just our being in this room today. It's really a miracle, and to be honored to be on a podium with such great scholars. Yeah, so one of the things that comes from reading, an inordinate number of Howey cases, more or less all of them, is, patterns do develop. And one of the things I wrote a lot about is really where do we locate the idea of investment contract, even predating Howey, as we all know, comes from state law, and it's redressing an issue. Sometimes people couch what purport to be commercial transactions or arrangement. Hey, would you like to buy, a chinchilla, for example? Got a farm, you could have some of them. And people know you don't really want the chinchillas. What you want is to experience the business that person is running. And so you fund them and they pool that capital, and you've got some sort of ineluctable modality of chinchillas there. Those courts over the years have struggled with. Sometimes the SEC has won, sometimes they've lost, sometimes private plaintiffs have won and lost, but they've looked at the fundraising and the pooling of capital and the relationship, which with all respect, Miles, I wouldn't call formalistic at all, the relationship between the parties. And they found that in some cases, notwithstanding the parties couching a transaction, a fundraising as commercial, hey, would you like some of whatever it is that I've got? Really, what the economic reality is that people were seeking to invest. What the Howey case law has just really never addressed is what happens if you could create an investable asset that people could buy and sell and trade very easily. And that's just outside the scope of Howey. I wouldn't say it's in or out. So we have to think about how to apply that. And really what we're talking about here is not seeking to use the securities laws to punish people, but rather seeking to use the securities laws for their intended purpose, to address transactions in the marketplace. And, when Bob and Alice, transact in ETH or they transact in some other token, those secondary transactions, those market participants need to be able to determine on their own, without consulting high-priced lawyers, without reading code, without studying the current state of a multi-sig, they need to figure out, hey, am I engaged in a securities transaction or am I not? If you could simply look at a token and say, oh, I see, there you go, that would be one thing. But if we create a construct in which every time any market participant needs to decide, am I engaged in a regulated activity, they have to make a time-consuming, expensive conclusion, then that really is very, very problematic from a market efficiency point of view. So the distinction is, when do I have something that is an instrument that no matter how it is dealt with, and I think Collins, I'm glad you brought up Section 12G because it's a good example. You have to know, is this something that's going to trigger 12G? As a broker-dealer, am I custodying a security or customer funds, or am I not? There are many places where you need to know, is this thing sitting there by itself a security or not? And that's an important distinction that our securities laws need to recognize. Now, maybe we'll be better off with something that Congress decides, here's a new framework, and here's how you think about crypto assets in the round, whether or not they're securities. And I think something could be said for that. But for right now, at least, we need to be able to make those distinctions so that market participants know when they're dealing with it. The people
Just to add, and I won't say I necessarily disagree with Lewis in the sense that I'm not sure, maybe if everybody's read his paper, there's maybe a sense that there should be a potential blanket, let's say, exclusion on secondary transactions. I don't take a position on that, but I do think historically our laws, and both the federal and state laws, have taken a position as to delineating the securities and the transaction itself. I think obviously we have Section 3 exempt securities and then Section 4 exempt transactions at the federal level. But then at every single state level, I think somebody said there are state regulators here, so they can obviously confirm. But at every single state level, we distinguish between exempt securities, usually in the prior section, and the transaction itself. So I think the past century of both legislative and rulemaking and jurisprudence does acknowledge that there are times where the transaction itself is obviously the focus of our inquiry, and then there are times that the asset itself is the focus of our inquiry. Sometimes those things may be one and the same. I think in particular for crypto, it's probably difficult to get to a place, at least from my end, where every single crypto asset would not be a security if it was only in a secondary transaction. And at the same time, there are probably some crypto assets that even if they weren't sold in exempt transactions, would inherently have properties that would make them securities. But I think that distinction should definitely not be one that seems to be somewhat controversial in some circles, because we've had that framework for almost a century now. So.
Great, Collins. Thank you for that. Lee, moving on to you, and then that's going to leave Coy, and then we're going to get more interaction among all of you. But Lee, what's your take? My sense is that your view, and again, correct me if I'm wrong as I try to summarize, is that the question has, to some extent, as to what's a security in the context of crypto, maybe more than just to some extent, has been asked and answered by the Supreme Court and by the courts over the years. Is that a fair summation? And how do you think about the following aspect of it, going back to various things we've heard, which is you take the 4 prongs of Howey, for example, or even a principles-based approach. There's still then, the practical question as to, but how does it get applied to any specific set of facts and circumstances? So that kind of translation of a 4-part test or set of principles to actually being applied to concrete real-world facts and circumstances and some of the tough judgment calls. How does consideration of that, if it does, factor in terms of your take as to what constitutes a security when it comes to crypto, and if there's anything for the commission to do to provide additional clarity or to rethink the approach?
Sure. Thank you, Troy, and thank you, Commissioner Purse, for hosting us and the staff for putting this together. I know from experience that events like this take a lot of effort, so certainly appreciate it. So I'm Lee Reiners. I'm from Duke University, and let the record show that we tipped off about 10 minutes ago. So go Duke. Let me also note that there's quite a bit of distance here between my fellow crypto skeptics, so feeling a little isolated up here. But let me just start off with a note of agreement on some of the things we've discussed. And obviously, we're here to start with, as we said, the top of the funnel. When is a crypto asset a security or not? But then I think sort of once that is decided, and I think it's pretty clear, and I agree with John that courts, not just in SEC enforcement cases, but in private litigation, and state enforcement actions. And let's not forget, the states have been the earliest on the scene when it comes to crypto. But after that, I think it is pretty clear, in my opinion at least, that some of the existing rules are not necessarily fit for purpose, and I think disclosure is exactly one of them. I don't think it's controversial to suggest that the information an investor in a crypto asset would want is just fundamentally different than the information an investor in Apple stock would want. I don't see how that's controversial. And obviously there's been custom disclosure frameworks provided in other contexts, asset-backed securities, and so this is something that Chair Ueda has suggested, and I would certainly be open to. Another issue, of course, is, well, should a broker-dealer be able to offer securities alongside crypto assets that are probably commodities, right? And I frankly don't see the issue with that, provided certain risk controls are in place, and that's perhaps an opportunity for the commission to use its exemptive authority, as others have suggested. So I put all that out there to know that I am not necessarily disagreeing with my fellow panelists on every single issue, but look, the Howey test is a flexible standard, And I have to disagree with Rodrigo's disagreement with John. And in over hundreds of cases, right? Judges have applied Howie's 3 or 4 prongs, depending on your perspective, to the offering of digital asset transactions, and found, in fact, there was a presence of an investment contract. I think, look, one issue that Lewis raised, and I put in my statement, is this notion of what I call the separation theory. And as Lewis pointed out earlier, perhaps I should have called it the embodiment theory. And this was raised in a ruling that Rodrigo referenced, but I will not reference it because I will follow the rules. In which case, sorry to throw you under the bus, Rodrigo. In which a judge, pointed out that the subject of an investment contract is separate or different from the investment contract itself, right? So, Citrus Groves itself were not an investment contract, right? But when packaged with Howie's promise to manage those and distribute profits, then the whole sort of scheme became an investment contract. And so I kind of grappled with this in my statement. And where I came out with is that there's a fundamental difference here between the subject of a security scheme and the security instrument itself, and that difference is the means of participation. So no one received Howie's promise earnings distributions by simply buying the orange groves, right? On the contrary, a token issuer promises profits by impacting the price of the token. Therefore, all the purchasers of the token receive profit through the issuer's efforts. And because tokens are fungible, it's impossible for the issuer's promise of profits to be paired with some tokens and not all tokens. So whereas the fortunes of 99.99% of Orange Grove owners have no relation at all to Howie, the fortunes of all token holders are dependent on the token issuer. So therefore, I think it's pretty clear the token is not merely the subject of the scheme. It is the security instrument itself. And I think if some of these cases been allowed to proceed, I think that's certainly where courts would have come out. So again, I think, Howie's flexible, it's facts and circumstances dependent. Another thing that's sort of come up is sort of the role of decentralization. We would probably all agree, I'm guessing, that Bitcoin is not a security, it's not an investment contract because it is sufficiently decentralized. There are no, there's no common enterprise. There's no others to point to receive your expected profit. So of course that raises the question then is, can we draw a line where, something is sufficiently decentralized to no longer be considered an investment contract? And I just think that's an impossible line to draw. And I would point folks to the CFTC's report that came out in 2014, or 2024, I'm sorry. Is a report from the Technology Advisory Committee on DeFi. And, the members of this committee that put together the report were, mostly worked in the crypto industry, including at DeFi firms. And they noted that decentralization exists along a spectrum across multiple dimensions. So you have governance, asset, user, application, data, network, protocol, hardware. So how do you determine when these dimensions are sufficiently decentralized enough to ensure profits don't come from the efforts of others? I just think, again, that is a completely futile task for any agency to try to attempt. Even if you do attempt it and you suggest, okay, we think in these conditions, it's not an investment contract, it's not a security, well, then it may be a commodity, and you might have the CFTC making a ruling that you don't necessarily agree with, right? So finding that DAO governance token holders who vote their governance tokens can be held jointly and severally liable for the actions of the DAO. And so this is why I think it's best to just leave it to the courts and have it be facts and circumstances dependent, because otherwise you're just never going to get to, I know we all want to get to this sort of promised land of clarity. And I just, again, I don't think you'll be able to do it. And my final point is, look, whatever outcome of this task force, and perhaps there's sort of a new guidance in terms of how the SEC is going to apply or interpret Howie to digital assets going forward, that doesn't mean that courts have to follow it, right? And to the extent the SEC is no longer going to be an effective cop on the beat when it comes to crypto, that void is going to be filled by private plaintiffs, okay, who are going to perhaps have a different interpretation of Howie. And in fact, we have seen numerous cases in which courts have agreed with plaintiffs across, not just digital assets, ICOs, but even NFTs, that they were found to meet the definition of an investment contract. States are not going to stop either. So while the purpose and intent may be to provide regulatory clarity, the effect may actually end up being the opposite. And that, I just want to end on that sort of note of caution to those who are doing this great work.
Great, thanks, thanks, Lee. And then Coy, to you. So
Best for last.
yeah, and then if there's stuff folks want to react to, reply to, try to get my attention, Teresa already has, and I got a question or two ready to go, which I may get to before Teresa I get to, just because I think there's a topic that I haven't heard mentioned that I want to make sure we come back to, and I'll let whoever wants to respond. But first, Coy, we've heard a lot of different perspectives, including the perspective that that Lee just mentioned, which is, if it were, as I understand it, and Lee, again, correct me if I get this wrong, if it were to be the case that the SEC were to be perceived to be scaling back its role from an enforcement perspective, that others may see that as occasion and or opportunity and or reason to fill that void in some way or another, which may then beg the question as to, on a net basis, where did things come out from a clarity perspective or otherwise, which speaks to a general point, which is things are dynamic, right? That if this changes, other things change in reaction, other things change in reaction. And so how does the whole system come to rest in terms of some equilibrium? That's much more complicated than a more static analysis where one presumes everything is the same other than the one thing that changes. I think that you're making, if I, again, understand it correctly. So Coy, from your perspective, as somebody who's practicing in the area presently, and you think about those kinds of dynamics, you think about the fact that there is a lot of jurisprudence on the books for a lot of decades now, as Lewis mentioned, having read all the cases. You also think about the reality that applying, I think, anything that's a set of factors or considerations or principles to, real facts and circumstances, there are judgment calls to be made in terms of how to proceed and what regulations apply, what regulatory bodies have jurisdiction or not. So in light of all of that, where do you stand on these questions? And again, come back to a common question I've asked a few folks. Is there a particular something that you think the commission should or could either do or consider that would make a big difference?
Yeah, thank you. And thank you, Commissioner Person, to the task force for having me. I think Rodrigo used a term that I really want to zero in on because I think it's directly responsive and maybe colors all of my comments. The term of regulatory humility, right? Lee, you're absolutely right. The SEC is not the only player here. You're going to have private litigation, but the other big issue that's going on right now is Congress is actively considering legislation that would assign spot market trading oversight to potentially the SEC and CFTC, or potentially just to the CFTC, right? So, these academic arguments are important and good, but at the end of the day, Congress is actively looking at this, and while they won't provide clarity on every single thing, they may provide clarity to the SEC and limit what it can do in this space. With that in mind, how, we have a lot of discussion about are these assets securities or not? And I think that's a little misleading. I think of the assets in the context of a transaction, right? Like, I understand we're talking about policy too, but the SEC has to keep themselves limited to the legal analysis. So you have to start at the statute. Teresa mentioned all the different instruments that count as a security. If you don't fit as an equity, you don't fit as a debt, you don't fit as a certificate of interest, all these things, the only thing you have left is an investment contract. So for most crypto assets, we're talking about investment contracts. That requires a contract, a transaction, or a scheme. So we're talking about transactions, right? And notwithstanding Lee's arguments about the embodiment theory, to date, no court has agreed to that. And it's a point I certainly see the argument. But there is no regulatory pathway for an embodied investment contract to have a secondary market at the SEC. It's just something the SEC has never contemplated before. It's just not a real legitimate pathway forward. So I think from the SEC's perspective, in limiting themselves into transactions and thinking of how they can provide clarity, keeping in mind the humility that Congress is looking at this space, it's starting from a principled theory of what Howey covers, what types of transactions it covers, and what it doesn't. And so I think as they've already started to do, and I applaud the work with the meme coin statement and the mining statement that came out with proof of work mining, is identify just certain transactions that you are comfortable fall outside of the securities laws. Or conversely, if there's a problem, if you think there's certain risks that certain transactions do fall within the securities laws, well, soliciting public input on that would be really helpful and useful, right? So I think, certain things that just happen, staking as a service, airdrops, I mean, stable coins, things like that, just basic transactions, secondary market transactions. I know there's ongoing litigation that we can't talk about. These are things that the SEC, I hope the task force will be able to look at and start carving out and carving in. Maybe the other important point that I just want to drive home here is that this is not happening in a vacuum. All of the activity that is ongoing is going on right now outside of the securities laws, with some notable exceptions, obviously, of folks that are fundraising pursuant to Reg D and the like. So if the SEC is going to inject itself into different transactions that has not injected itself yet, I think it better to have a couple things in mind. One, it should obviously have a sound legal argument of why this is a transaction that is subject to the securities laws. Two, it should have a clear policy goal of what it's trying to achieve, who it's trying to protect, and why. And three, without even knowing the transaction, I can guarantee you there's not a pathway currently at the SEC for that to be achieved in an efficient manner. So I encourage that in the same breath, the thought of if something is within the securities laws, the immediate conversation needs to pivot to how can compliance with the securities laws be met? And a more proactive agency from what we've seen in recent years would be very welcome. And I'm super encouraged by the efforts so far by the task force, and am grateful that you're doing the work that you're doing.
Great, thanks, Coy. I know Teresa has some thoughts that she got my attention on. Is anybody else maybe everybody, Teresa, John, Collins, anybody else? Lewis. I'm going to do my best here. Anybody else? Let's see, Miles. I think I'll just go through the list here. It just looks like. So I thought might be the case. Anybody else? Anybody else? Yeah. Okay. Ben. All right. If I miss you, and if there is anybody else as we get through, just chime in. So maybe in that case, I'm just going to go back through, where I'm going to bounce around a little bit and exercise some moderators' prerogative here. But there is a question, and I'm going to ask everybody to be brief in their kind of next comments, but also in response to the following, and maybe somebody just get my attention if they want to take this up. One of the things that I didn't hear mentioned, and I may have just missed it, is express discussion about use and consumption as compared to investment. So you think about United Housing versus Foreman, which is a really important part of the jurisprudence, as well as market forces versus efforts of others, if you're looking at it from a Howey perspective, right? There's a lot of things that can influence a price, but that doesn't necessarily mean, according to the courts, that it's the kind of efforts of others that would satisfy that particular prong of Howey. And there's case law, not a ton, but there's case law to that extent. And again, use consumption, you think about in the context of Howey itself, to twist the facts to what they weren't, but just to illustrate the point. If in Howey it had been the case, it was not the case, but if it had been the case that the individuals involved could have come into the groves, picked some oranges, eaten some of an orange stand, maybe went to a farmer's market, that case very likely would have turned out differently, or at least there was the prospect that that case would have turned out differently. And I think there's really, you see that versus Foreman in terms of use consumption as juxtaposed to investment. And then there's another layer to it, which is speculation the same as investment? I think some folks talked about that to suggest that speculation is not the same as investment, that there's a lot of things people speculate on, hoping that it becomes more valuable, that folks wouldn't think of as being a security. So if you take those points, which I think hover around a lot of the discussions over the years as to what is or is not a security, in particular, the use, consumption, United Housing versus Foreman, and if market forces are the thing that are determining the price as compared to meaningful efforts or managerial and entrepreneurial efforts of others. Anybody want to offer a perspective or two? Miles?
Yeah, so I mean, I think that the SEC actually got this right back in 2017 and 2018 when, you know, they basically said that the presence of utility is not enough to exclude an asset from the securities laws regimes. I think everyone would agree here that if Amazon started accepting Amazon stock to pay for AWS services, we wouldn't exempt Amazon stock from securities laws. And I don't think that we should do the same with digital assets. It's undeniable that there are people that are investing in digital assets. It's undeniable that some of those have use cases. But trying to grade the line between where there's more consumptive intent than investment intent, I think is even more impossible than defining sufficient decentralization. So as a result of that, I think that's kind of a bridge to nowhere. I think it's easier to focus on, the efforts of others and where the value is being derived from a given asset. Again, going back to my example earlier, with Ethereum, there is a financial interest in the operation of the network. That network functions without human intervention and control. It's fully autonomous and permissionless. No company going away could harm the economic value of that asset. Compare that to a share of Apple stock or FTT, right, where the clear economic value was derived from the profits of an enterprise that were then being deployed back into that asset. And so I think, again, the efforts of others, I think has been in the 2019 framework that the SEC put out was used as a very expansive way, 40 different factors of very subjective nature, which has been very difficult to enforce. And I think that if we can constrain it to a more objective perspective, one that's focused on control, it's a lot easier to define what, decentralization is and what may de-risk an asset and therefore justify not applying securities laws.
Good, thanks, Miles. Sarah?
Just as a small point, right? I think there's two extremes here of one, your asset got infected by a securities transaction and is a security forever. And on the other end, there's sort of people arguing for more of a four corners test is based on the intrinsic characteristics of this asset. We wouldn't consider it a security, but the thing about tokens is they aren't oranges. Like while the issuer or the initial development group retains control over all aspects of the network, the dApp, the token, they can inherently change the functionality of the token. The token is whatever they want it to be today or tomorrow. And so that won't give us certainty. And so that's why I do agree with Miles that there's this inflection point where they no longer can control those characteristics. And then it is de-risked.
Chris?
Yeah, I just like to, I'm pretty, I guess, sympathetic to a kind of control standard. I mean, insofar as it's not foreign to securities law in any way, right? I mean, when you think about, definitions of what constitutes a distribution, or when you think about minority shareholders and their rights towards others, that's a certainly cleaner than utility. And yes, so the Supreme Court on various occasions has tried to sort of draw that line between the two. Maybe since we were asked to give each other questions, you have any suggestions in terms of how you would actually implement this? Is there like a percentage number that you have in mind in terms of control of network or
well, I think it's very important when we talk about control, right, that we're not talking about just the disbursement of control. So while I think that there is some importance in looking at thresholds, right, I don't think if you were to just solely say, hey, look, if everyone owns 1% of this network, then it's not controlled and therefore we don't apply securities laws. I don't believe that that's correct. I believe that partnership interests can be securities. Partnerships can be very decentralized. Right. But the difference between an ordinary partnership that might be decentralized and a blockchain network, right, is that you can eliminate mechanisms of control, right? You can make it impossible for anyone to actually change the system and thereby influence control. And where you have that, right, you eliminate the ability of anyone to unilaterally affect or structure the risk of the underlying asset, right, and affect the probabilistic outcomes associated with that asset. And as a result of that, so if you look at things like autonomy, permissionlessness, right, all of these things that transform, blockchain networks from being proprietary software like Apple's App Store into things that function more like public infrastructure that no one controls, I think that's really the core criteria. So I think, voting rights, voting power is part of that, but I think it's only one part.
So just to clarify, Mo, so control means that you could modify the code, and if no one can modify the code, there's no control?
I think the mechanism for modifying the control is certainly a worthy kind of criteria. But for instance, there are systems where no person can modify the code whatsoever. Uniswap is a smart contract protocol that has smart contracts deployed, which is programmable, executable software deployed to a blockchain, right? That are completely immutable. No one can change how they function. As a result, no one can change the economic value of those smart contracts or the economic value of the token that relates to those smart contracts.
But
So-
what if an entity can just release an updated version of the protocol that's not the same as the previous protocol, but they still, that's where people migrate to?
Well, so what the critical criteria there is, you're absolutely right. Someone could deploy Uniswap version 20 tomorrow, right? But where do the network effects of the system accrue, right? And that's what the key economic kind of decision or analysis relates to. Network effects in a system like Uniswap and a system like Ethereum accrue to the network. Therefore, they accrue to the token holders. If someone tomorrow was to say, hey, we're going to deploy a new version of Uniswap, that version of Uniswap would have no liquidity in it. Therefore, it would be completely valueless. The only way it would ever have value is if people move liquidity from prior versions of the protocol to that version of the protocol. As a result, right, that clearly demonstrates that the network effects of that system accrue to the protocol and not the company that deployed it. And that is a very key distinction for the overall risk profile of the underlying asset.
But, but Miles, in fairness, I'm sorry,
Lewis,
just
we just pause for one sec. I want to try to get some of the, and Lewis, you're shortly in the queue, so you can kind of refresh on that. So we got about 10 minutes. And so I'm gonna ask everybody to be quick in terms of their responses, and then we'll have the break, and then we'll have after the break, and we'll figure out to make sure everybody has a chance to get their thoughts in, and then we'll go to the questions that have been submitted. So let me, if Lewis, you can just hold off for 1 sec, and Teresa, let me go to you, and then to John, and then to Collins. We can be quick, and then we'll see where we are from there in terms of timing.
Thanks. So a couple of things I just think are really important to think about is Howey was never intended to regulate an entire industry nor technology. If you look at what it was originally, it was more kind of these one-off situations. And after we saw, like, you know, what was happening in these new assets, and the 21A report, you know, indicated that, and how the commission was approaching it. From there, once you see that this is an entire burgeoning industry, Howey is not the appropriate test, in my view. And I think that that's when you have to start thinking about what is this, and just like we have historically throughout our entire through the United States just being in existence, how we've handled these things, it would be, you know, start thinking about how to apply, what should apply, think more about what these assets are. And then I question the responsibility, how responsible it would be to just let this play out in the courts, this test that's very, movable, no limits. It's had problems before the digital assets industry, and it's going to have problems afterwards too. And I think we can also look to, there are other aspects of the securities definition that are triggered by digital assets. Yes, it's most often investment contracts, but absolutely 100%, no way does that cover all of them. There are other types that are not an investment contract. And I think that's important when you're trying to figure out how you're going to analyze these. And I also think it's important with people talking about the tripart mission, the tripart mission is very important, all three equally important, and that all of those were supposed to be done while mitigating or minimizing intrusion to legitimate and honest business. And if you look through, particularly from the Thompson bill, and I'll wrap up, the Thompson bill, which was rejected because it was too onerous, and you look at how that evolved into the 33 and 34 Act and Roosevelt's statements, all of this, so much focus was on the fact that it has to be minimizing that effect on honest business. And I don't want us to forget that, because we have forgotten it for a while. And there are other instances we can look at, and particularly with people thinking that Howey applies to everything like this, is in the 50s, in 1958, there was a trading stamps release, and those trading stamps, you know, the little gummy stamps, and you put them in your book, and everybody would get these stamps, and they were worth like nothing, maybe a penny if that, you know, and there was a 168, I think, billion-dollar market for these things, and there was secondary trading and all sorts of things with these little gummy stamps, and the issuers give them to the distributors, and then there were the merchants. There was this whole infrastructure, and the SEC opined that those were not evidence of indebtedness. They did not even consider Howey. 12 years after Howey, they didn't even think about it, and they rationed, if we were to regulate this as a security, well then railroad tokens, all these other things would fall in. And clearly the securities laws are not supposed to handle all of these commercial transactions. And so if an entire industry and technology of trading stamps evolved, we would have to come up with this whole new thing of how do we handle trading stamps. It wouldn't just be looking at it, you know, as a Howey test for every single time and letting the courts try and figure it out, coming up with different answers each time. And then there's absolutely no clarity, no fairness. And if you are going to hold somebody accountable, and I think of, you know, you're wearing a white suit and you get sued by the SEC, now you have a black mark, you can never get it off. And if you're going to hold somebody to that, and they're going to have to live their life that way, these are people, and companies are full of people. All of this, let's not forget, we're all people, even though we're talking about technology. And if you are going to hold that person responsible and then 2 months later say, oh, never mind, it's not a violation for anybody else, you know, where's the fairness in that? Thanks.
John?
Thanks. I'll be quick. There's an elephant in the room to me. You know, there's been the wholesale demolition of the crypto enforcement program, right? It looks like they've closed all the investigations. It looks like they're closing or about to close all the litigation, all the appeals. They've shuttered the crypto unit, given it a new name. They've shipped the head of litigation who did all of crypto to OIT. So is this pivot worth it? I get it. There's definitely a mandate. I believe that the president had a mandate with respect to crypto and wants to be the crypto president. And so I don't necessarily think that any of these steps are something that there isn't a mandate for. But I've taught securities regulation for 20 years, you know, 15 years Georgetown law, almost 5 years at Duke. It's a total gray area, securities laws. If your idea is, hey, we want to make these laws clear, it's just not going to happen in any area. Yeah, I mean, but I appreciate the nobility of the goal. When I was chief of the Office of Internet Enforcement, before that, when I was special counsel for internet projects, I was an internet evangelist. I set up the first computer that the Division of Enforcement had with an internet access and taught people how to use it. I met with e-brokerage firms almost monthly, just like we're doing today, to find out what we were doing right, what we were doing wrong, and really try to work out things that to make this disintermediation, that's what everyone talked about at the time, to make all that possible. It was exciting. But there were people out there selling Reg A offerings or Reg D offerings on internet trading facilities and advising people to buy them. And it was like a driver's ed. Remember those driver's ed films when you were in school where they showed you every conceivable violation? That's what these were. So we sat around and we figured out how to get rid of those. I just don't see it as far as this innovation, whether it's a gummy stamp or equivalent to an American Girl doll or a Pokemon card or whatever. Is this pivot? Is this dramatic, unprecedented, right? Let's all agree the SEC has never done anything like that like this in its history with respect to such a successful enforcement program. Is that worth it for this this technology that you know, ask yourselves, is it something that I really care about? And is this pivot worth it?
All right, so I'm gonna keep us on time. I got a couple of minutes left, so here's what I'm gonna propose. Colin's time for the first chunk. What I have in the queue is Lewis, Ben, Sarah, and I think Miles. There may be someone on the panel at the break who tells me to get them in the queue as well, and I'll do that. I know that there's the effort, and we will take questions that have been submitted. We'll make sure that we are able to manage all of that, so we give that due time, and also make sure that you all have the occasion. So that's my list. If I missed you, you know, tell me at the break that I missed you if you want me to add. But with that, to keep us on time, we'll wrap up with Collins, and then we'll take the break, and then we'll come back.
Sure, thanks. I think just two final points to respond to. So first, I think that this notion that it's impossible to come up with any type of guidance or framework is it's kind of weak. I mean, I guess I'm in Washington, so I can say this in an inspired sense, but like we are America, like we put people on the moon and stuff. We can figure out how to write words to give people more clarity on paper. And I think there's two quick examples of this that came out of this kind of meeting that are almost obvious. So for instance, I think, Lee, as you spoke about kind of your point, one of the things that you kind of inherently did was start positing a vertical commonality test as part of your Howey analysis. I think you said something like, all of these tokens intrinsically link the fortunes of all of the token holders. That alone kind of indicates a lack of clarity that the SEC could start working on today. Right now, the SEC has argued both for horizontal commonality being required, pooling assets and bringing funds, and then vertical commonality, where it only requires that you have some type of intrinsically linked fortunes with the issuer. That becomes problematic if you're an issuer trying to figure out if you're already within that regime. One clear example, I think, to finally answer one of your questions, I don't know if any of us did, is what could the SEC do today? I think one of the first things is just start giving guidance as to where their views are, as to what their views are on the problems of Howey. So to your point, is an investment of money satisfied when somebody receives an airdrop, but it's expected that they've created a market for that token? For horizontal commonality or common enterprise, is the SEC's view that it can be either horizontal or vertical, or is it both? That type of guidance alone doesn't require that they come to a decision on what these assets are, but it does give us more predictability as to what we should expect when we're going through these analyses and not going through 50, 60 questions and that type of guidance. So I think that type of clarity, as well as guidance on what type of information is required for a system to potentially meet the type of standard that Miles might be promulgating. And I think that goes to my last point, which is those standards that we look at, and I think somebody else mentioned the original purpose of securities laws. I went back and looked at the 33 Act's first congressional hearing notes, and there was a Senator Sam Rayburn. One of the first things he says is, the goal of this act was to place on parity with management of corporations, the buyers of securities, and then the buyers with the sellers on the same plane as those sellers. And I think what Miles's point goes to is that when you have certain characteristics in a protocol or an application or something else, I think it inherently places on parity the purchasers of that token with the purchase of management. And so to the example that he gave, with Uniswap, I mean, your Uni token can't even affect the operation of this protocol. I think there are probably even easier examples to look at where you can say, look, we're looking at this, and at some point when they've lost these elements of control, management has just as much control. They're on the same level of parity as the same buyer. And that's why I think that some type of measure of control is probably the appropriate kind of measure within the context of our historical securities laws. So yeah, I think we might have 2 more minutes for Lewis, but I don't know, Lewis.
All right, so we'll give 1 minute. So Teresa has a question for Collins, so we'll do that and wrap up in a minute, and then we'll have a break.
What are the characteristics that you're talking about that would implicate the securities laws?
Yeah, so I think, and actually, again, not to piggyback too much off Miles' paper, but they did a pretty good job of outlining, I think, 3 standards, if I can recall correctly. One was economic independence, and that economic independence is basically what I think he was speaking to towards the end. The other was, as you mentioned, with governance control.
Sorry, I don't get that. What do you mean by economic independence?
That's totally fine. So economic independence, I think, in the example that we were just talking about, is do the benefits and the economic benefits in particular inure to the benefit of the holders by virtue of somebody exerting continuous efforts, and that essentially becomes the essential managerial ones, or does it inure to the benefit of those people by virtue of the operation of the protocol, independent of the actions of that initial issuer? And so, for instance, when you look at a Uniswap, it doesn't matter what Hayden decides to do when he wakes up today. Like Uniswap's value is going to continue to accrue to the liquidity providers that provide liquidity onto the protocol by virtue of the fact that the rules automatically and consistently will always execute in that fashion. But to his point, if somebody launches Uni V2, perhaps they add some type of control mechanism into it. Suddenly, you don't necessarily have that economic independence. It may actually be the case that you're actually dependent on that issuer or that developer to continue doing something or refrain from doing something in order for you to be able to capture that value. And I think that's a good example of where economic independence becomes really critical. The other 2 elements, I know we're over time, I'd probably look at his paper or some of the other folks' papers up here. I think Sarah's done a great job at this, Miles has, and a lot of other people have written about that. But those 3 elements, economic independence, governance, and forgive me, Miles, forget the last one, are probably 3
operational control.
Points. Yeah, operational control. Thank you.
All right, great. So we are now, in fact, going to take a break. What instructions?
Enforcement looking jackets. They are friendlies. They are no one to be afraid of. They are just taking your cards. They will not report you to anyone. I mean that. And the second point is, I know we've been getting questions on the web. So please continue to send those as well. We're monitoring them and we'll get through as many as we can. And finally, we will have a small snack break. So when you exit here, I see some joyful faces. That is also the expression I make when I hear about snacks. So if you exit here and go left, and folks who work at the SEC, if you could just direct people towards the multi-purpose room, we will have little snacks in there and reconvene here at 3:30. Thank you.